call this meeting to order. But we're not a meeting of the Offenders Rehabilitation Board of Trustees. How do you guys normally do your roll call?
Usually, with this instruction, you will do a roll call. Okay.
Please do so.
Okay, roll call. We have, Chairman Attorney Shane Blatt. Mayor, just acknowledge the present.
Present here.
Vice Chair Attorney Jeffrey Moots.
Present via Zoom.
Thank you. Member Ricky Hernandez. Present. Member Janet King. Is she on, Ken? No. She's not on. Okay. Member Don Massa.
I'm present.
Member Jojo Perez.
Present.
And member Dr. Christiana Whitman.
Present via Zoom.
Thank you very much, Chairman.
So
Accounted for.
seems to me that with the people present, we have a quorum. And as far as food foods, you do some recitation of that.
Yeah, so for the forum, in the past, we basically have acknowledged the forum. Everyone except for, right? Okay.
Does
And
everyone
then, yeah, so motion at this point.
have a motion that there's a quorum?
For to establish. Yeah.
The motion.
Second.
Okay, and then for the proof, do notice, usually, it's attached, to the packet. So usually the chair will just go through and, basically ask for a motion to approve.
Okay.
And that's-
Attached, okay, I acknowledge that attached to the back of the packet that was distributed for the meeting, there's indication of the notice. Is there a motion to accept this notice?
We just have to acknowledge, right?
Yeah.
I think we just have to acknowledge.
Does everyone acknowledge that this meeting has been duly noticed?
Yes.
The next item on the agenda is approval of the meetings or approval of the minutes from the last meeting, which was September 3rd, 2025.
Motion to accept the minutes.
For a second,
Second.
all in favor?
Subject to correction. right?
Well,
Correction.
yeah, is there? I guess
It's been
I guess
motioned.
yeah, is there any discussion anybody wants to have regarding that motion? I don't see any indication of discussion, so I'll put that to vote. All in favor?
Aye.
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 And then we can get on to the old business. And that's regarding the updates to the Board of Trustees bylaws, which was tabled from the last meeting. Tabled subject to a question essentially, which required briefing, distributed by Shane prior to the meeting to everybody. There's been 2 opinion letters. Has everybody had a chance to review materials?
I believe.
Do we need further discussion?
Do we have to move to go through the bylaws first, or do we have to go through, I'd like to go through this letter first, so I didn't get the one from, from Attorney Moots.
You didn't get the one from, that's the one.
Yeah, so,
So you
I
didn't
just
get a
got
chance
it,
to, oh, you didn't
yeah.
get a chance to review it.
no, I don't know, I read the one that got sent me this morning, but
Okay,
not this one. Can I go through it real quick?
sure.
The speed reader, but
I think we have the bylaws motion tabled. currently and tabled subject to this question, I think, if I remember correctly, it was raised by Jeff. Specifically to the application of the AAA to our rulemaking process. And this prompted the opinion letters before us. So we can have everybody take a few minutes to look over anything. I know the one from Jeff came in. Thank you, Jeff, for putting the work
Yeah,
in for that.
Like I said, I'm sorry that it was late. It's just been a hectic week. And with travel and everything.
On that item.
Sure.
We're currently on old business related to trustee bylaws. I'm just reviewing the minutes because the debate around bylaws which were related to the board's official start date. And the question as to whether we could adopt these internal bylaws for October when our meeting is.
Well, yeah.
Is that the?
Yeah,
Is
well,
the,
that was
Oh.
beyond that was,
the questions about applicability of?
yeah.
Oh,
There is some relationship between the bylaws and the question because depending on the answer, that will impact some of the powers and the way they're described in the bylaws. And in fact, it will make a big deal to some of the content of personnel procurement and the establishment of rules and regulations. All of that is impacted by the question of separation of powers. By the way, I mean, basically what it comes down to is the executive director's analysis means that we're under the supervision of multiple branches of government. And that is a violation of separations of powers as defined by the Guam Supreme Court. So if his interpretation of what the statute says is correct, then the entire Public Law 3848 is inorganic and invalid. Because as I laid out in my letter, you can't have an agency that's under the supervision of multiple branches of the government. That's exactly what that Bordallo, the Public Defender Service Corporation versus Governor Bordallo said, that the governor had no authority to regulate anything to do with the public defender because the public defender was squarely under the judiciary. So we got to pick, we got to be under some branch, one of the three. We can't be under multiple ones. So as I laid out in my memo, the legislature doesn't have the power to administer agencies. It doesn't enforce the law. It doesn't comply with that. The judiciary has their own powers, but we're not under the judiciary anymore because this Public Law 3848 specifically removed us from the judiciary. So what we're taking is the same position. Say again?
Attorney Moots.
Yes.
It removed us from them actually overseeing our operations, but we're still technically under judiciary. Nothing really changed.
No, we're not. We're no longer technically under the judiciary. It says we're subject to their organic act powers, which means we're subject to, okay, let me back up. If we were under the judiciary, then none of us who were not appointed by the Chief Justice should be members of the Board of Trustees because the other branches cannot be involved in the practice of the judiciary. We were created as a public corporation within the government of Guam, which, as I know, the Guam Supreme Court noted that then makes you part of the executive branch, and it made the stuff in Chapter 5, Title 5, applicable to autonomous agencies. The language that describes us as a public corporation within the government of Guam makes us an executive branch entity.
Yes, you have the floor.
So, I mean, obviously, I think it's a healthy discussion. I mean, one that we should be having, but I mean, it is, you know, it's a major change. It's a really significant change for us. And I think if we looked at the old law, it didn't specifically define us as being under the judiciary, but we're doing the business of the judiciary. I mean, it doesn't have to be set out like that. I think the Constitution would only require that the government appoints an attorney, but our statutes make it the obligation of the judiciary to do that. So we're really doing the work of the judiciary. I don't see an executive function here.
Well,
It's like the major tweak that I saw in Trustee Moots's memo was that they used the word entity, but that didn't seem to change our function or really where we came from, or, you know, 50 years of law. I mean, but this would be a major disruption to how we operate. So I think it's something that we should really be cautious of.
what you're saying right now then is we are a judicial entity. Is that correct?
And I'd also like to add that we've been a judicial entity since, well, 1975, and then the decision of the trial court in 1977, PDSC versus the Ricky Cordalio, in which this specific issue was addressed. What is the function of the Public Defender Service
No,
Corporation?
its function was, the whole purpose of that case and the holding of that case was whether or not the Public Defender Corporation at the time, pursuant to the statute, was part of the judicial branch, so that the executive branch had no control over their finances. That's all it decided. And if we were remaining under the judiciary, there was no reason for the enactment of 3848, which creates it as an independent entity that says it's not under the judiciary. It takes it out from under the judiciary and creates it as a public corporation. The judiciary has no organic act authority to operate a public corporation as defined in the statute. And it has huge implications because the bylaws regarding the personnel, you now come under the Civil Service Commission. If you're part of the executive, you come under the rules, the procurement rules. Yes.
Sorry, yeah, and I see what you're saying, Jeff, and I think where we're coming from is, and the question that we've asked is that, you know, it's saying that the law specifically took us out of the judiciary, but I think what we're saying is we don't see where that happened.
Well, Steve's original opinion was we're under the control of both the legislature and the judiciary. So that's what his memo says.
Only has the authority to appropriate funds, and the judiciary is where they're the ones that appoint attorney or allow us to appoint attorneys, investigators, experts, as well as to administer.
I understand that, but
Because
if that was the case,
and I just think, the right to counsel is not an executive branch function, as what was stated in the Cordalio case, that it's a judicial function, and so that's why we fall under the judicial branch.
then
And there are entities within the judicial branch, like the compiler of laws, that used to be an executive branch function, but now it falls within the umbrella of the judiciary. So we're kind of like one of those, or the Office of Public Guardian. That's not necessarily, that's an executive branch function, arguably, but they're serving that role too, because you know, they're protecting certain constitutional rights by the due process. So those are other entities within the judicial branch that you know, fall within the umbrella of the judicial branch. That's all we're saying. The entire statute, 3848, not once does it mention anything about falling under the jurisdiction or
Okay,
control of the executive branch.
the problem is in section 1 of 3848, it specifically notes that it is removing the judiciary's leadership has been necessary to ensure the right to counsel during the development of indigent defense. It is the legislature recognizes the importance of establishing an independent, right? Independence. So from a single branch of government. Unfortunately, if that was the case, that we're still under judiciary, there is no need for 3848.
Well, it did change some other things too. I mean, it changed what's the board gonna look like and what's
But
our.
that's just it. If we're under the judiciary, the board can't look like this. The governor has no right to appoint anybody to a board under the control of the judiciary. The legislature has no right. That is interference with the judicial branch of government.
Jeff, you're getting that from the Bordalio case? Is that where you're getting that?
No, I'm getting that from all the Supreme Court cases that are in my memo.
Oh,
In re Gutierrez, in re Felix Camacho, in re the request of Lou Leon Guerrero. All three of those cases, the Supreme Court has said that that you got to be in one branch. Okay? That one branch cannot reserve powers for itself that belong to another branch. And that the government is three branches, that's it. So we got to pick a branch. And the legislature isn't the branch because it can't execute the laws. The judiciary can't execute all the other laws like this unless we're specifically placed in their power. This is an entity that is designed to execute the law as written by the legislature, to carry out functions that are executive in nature. The whole administration of the corporation is an executive function. Now,
Yeah, and that's that's your opinion, but the opinion that we have to rely on is the Public Defender Service Corporation versus Bordalio, which.
right, and that said that the legislature specifically put the board under the judiciary.
The court, in that ruling, the court said that the defense function, appointing a counsel for a constitutional right, is a judicial function. Nowhere in that opinion did it say that it was an executive branch function, because if it found that it was an executive branch function, then it would have said that the Chief Justice can be, the chair of that board. So there's never been any legislative intent that PDSC falls within the executive branch. And no, I don't think, and the court ruling specifically in PDSC versus Bordalio was that we're not performing an executive branch function, we're performing a constitutional right that's protected by the judiciary. And that's what the, Supreme Court rulings in that Gutierrez and the Gita case, they were actually looking at what is the function of the agency or autonomous agency at issue. And in ours, there's really, we're performing a constitutional right afforded to our indigents, protected by the Organic Act as authorized by, the Constitution. So it's really a duty that's really owned by the judiciary and enforced by the judiciary. We are performing a judicial function. The independence aspect is that we have an independent board that's created.
Which is in violation of the Organic Act if we're a judicial entity. We are subject to the control of the Chief Justice then.
Well, not directly, right?
Yes, directly. The Chief Justice, if we are part of the judiciary, then all of our rules and regulations have to be approved by the Chief Justice.
I think that's what the law was trying to do, was separate us and take them off the board.
Take
that
us
they
out of the
don't have-
judiciary.
So that they don't. It would be more like. We're their sister company, not they're our parents and we're their children. I think what they wanted to do was make sure that the judiciary, the judges themselves didn't have ruling over this body right here. That was why they took them off this body.
Right.
But I think for us, I mean, why are we trying to fix something that doesn't need to be fixed for the last 25 years? We've tried to put everything in place to make sure that our people were protected. We developed the APD, we developed the EJC, the Civil Law Center, and now we're doing this. The
All
public
through
law.
the judiciary.
Okay, so what is it that you need to see to make this seem that it's right? Because I think what should be important right now is that we just try to start working on our bylaws to see in fact if we are going to do or we're gonna run this the way that it should be ran.
Oh.
And that we don't have the judges overseeing this part of what we're trying to do.
That's
So
just it.
what
If we're
do you
still,
want?
if we're still in judiciary, then we still report to the Chief Justice. He has the authority to run the agency. All of our procurement, all of our personnel and everything has to be through the judiciary. And if we're saying we're a judiciary, a judicial branch entity, and that we report to the Chief Justice, then we need to act that way.
Well, Jeff, just to clarify, right, even with the previous board, you know, procurement regs and everything were approved, of course, by the board, but decisions and operational and management decisions weren't made through the Chief Justice. They were made through the corporation with approval from the board.
The board,
So I
which
guess-
was consisted
I guess-
of the judiciary, right?
Right, what I'm saying is on an operational
Two
level,
members of the judiciary.
right, on an operational level, we didn't feed things through the judicial council, through the Chief Justice, presiding judge, nothing went that way. Basically, it was, you know, giving us what they perceived as were the regs. And a lot of times, yeah, it did mirror what the judicial council approved for the court. So I guess operationally, because it's starting to leak down that way, but operationally, it's wasn't done specifically through the Chief Justice, right? But it was done under the judiciary.
Everything in the judiciary is under the control of the Chief Justice. So,
Yeah, we don't dispute that, but I guess
Right.
if
so the question is,
stating it, it's, I just want to make sure it's, you know, represented.
but the question is, are we saying that we are subject to the judicial branch and subject to the control of the Chief Justice and as an entity of the judicial branch?
Well, I think we're saying we're not in the executive branch because nothing gives us that impression. It's not in the
Well,
statute. It wasn't. the
John, you
case
got to
when-
pick a branch. Which branch are we?
Well, and you know, Jeff, even if we are within the judicial branch, but as you know, Supreme Court case law says that the legislature is authorized to, you know, as long as it doesn't interfere with the operations of that branch, they can set rules and pass laws affecting that organization within the branch, right? Like the Gita case, or
Right.
you know the Juan Clearinghouse case.
But they cannot completely remove the control of
Yeah,
the head of that branch.
Exactly. So right now, the Chief Justice appoints 2 members, the governor appoints 2 members, and the legislature appoints 2 members. So we've not completely removed the Chief Justice's involvement.
Then our rules and regulations need to reflect the policies of the judicial branch.
Which they pretty much
Well,
do.
they can't because our statute says all of our personnel policies are subject to 4 GCA. We can't be subject to personnel policies within the 4 GCA if we're part of the judiciary because 4 GCA doesn't apply.
Well, that's not true.
Well,
The
just,
judiciary,
4 GCA routes it right back to this board.
yeah.
So, and the board constituted by 3848 kind of puts it right back here with us, right? So, yeah, that's what we're trying to say. It's even in
That's just
there.
it.
4105, it's stipulated which boards specifically govern those rules and regs. And even inside those personnel statutes, it's to be consistent with what the executive branch does, but gives the discretion to make.
And the Civil Service Commission, pursuant to 4501, the Civil Service Commission hears appeals.
Right, but I think there's also under the judicial branch, right?
But we can't be, Shane, we can't be under both. If
No,
we're
I
under the
understand
judicial,
that, but that's the way the law's written.
then the law is in violation of the Organic Act.
Hold on. Jeff, you're making the point that we can't be in both, which I
We
understand.
can't.
According to this in re Gutierrez case, you're saying that they can't delegate power to a different agency. But I think the intent of the statute was to create this as an independent agency from both judicial, legislative, and executive power.
No
So they're
such
not
creature
designated-
exists.
Hold on, they're not designating it to another agency or another branch. They're designated to an independent agency, which does exist in other jurisdictions.
But it doesn't here. The Organic Act says there are 3 branches of government, and because the statute says we are a governmental entity, we have to be within one of those branches. We're making the same argument now that Doug Moylan is making about the OAG, that they are independent of all the branches of the government.
Well, that's totally different because the OAG is performing an executive branch function.
Right.
No one is saying we're performing an executive branch function. If you're, because of what
If you're
you're
saying-
correct,
If you're saying we're judicial, then we're part of the judicial branch. And we have to follow the judicial branch rules. They cannot impose executive branch rules and requirements on a judicial branch entity.
Who's imposing the executive branch rules?
The legislature is by saying our personnel policies are subject to 4 GCA 4105.
Correct, but that existed prior to as well. So I mean, was the argument the same in the prior, prior to 30 and 40? That's where I'm getting at. 4105 was designed to part out where it needed to part out, which entity.
Who wrote this statute? Who drafted this statute? Who drafted 3848?
well, I mean, it was the legislature, they had a public hearing, there were amendments made.
Who provided them the basis for the statute? I know they didn't draft this up on their own.
Oh, yeah, the Sixth Amendment Center, and the committee within the office, we work with the judiciary as well. And Senator, obviously Senator Teddy Weed, Senator Bloss.
So are we now saying we are a judicial branch entity?
Well, I'm not saying that, I'm saying that the legislature, when they enacted public law 3848, did not place us within the executive branch and clearly indicated unambiguously that we are the entity that falls under the jurisdiction of the judiciary.
No,
and the-
it does not say under the jurisdiction of. It says subject to the Organic Act authority of the judiciary and the legislature.
Yeah, and in that.
Everybody falls under the Organic Act authority of the legislature and the judiciary.
That's
That adds
correct.
that adds no jurisdiction and adds no impact on us.
I mean, it does have impact if the organic and the constitutional, right, business that we're conducting is judicial in nature.
Yeah.
I mean, there is impact in that.
Then we are a judicial branch entity.
But
We
I
gotta
also-
choose.
Yeah, and I also think it goes back to what the chairman was saying, was the intent wasn't to, it was to make us operate so that that business can be a conflict without having to worry about, interference and whatnot.
But
So
we
I
are,
get what you're saying, we have to choose, but if the decision and the context and historical nature of this corporation leads us one way to decide how it's gonna be done. I think
the
that's-
historical context has no impact on the Organic Act. We got to choose a branch. If we're saying we are a judicial branch entity, then we need to conduct ourselves as such.
Well,
So,
going back to this, we gotta choose a branch thing. I mean, I realize you're concerned about making the same argument that Doug is making, right? But within the statute itself, and the legislative intent, it's trying to make it independent. Is that the same? I mean, is there the same statutory framework that raises the concern from the AG's office?
No. The problem is the AG is claiming that as an elected official, not part of the executive branch in the Organic Act, he's not subject to that. And the Supreme Court has said he's full of it. The problem is here, we are created as a public corporation within the government of Guam. So within the government of Guam, everybody has to exist in one of the three branches.
That's the part I'm not sure I understand. Why do we have to exist in one of the three branches? Why can there not be an independent agency?
There are no independent agencies that are within the if you're within the government of Guam, the government of Guam consists of, according to the Organic Act, the executive, the legislative, and the judicial branches. That's the government. So if you're going to be in the government, you got to be in one of those three.
But governments of other jurisdictions have.
I don't care what other jurisdictions have. We have a strict separation of powers issue. According to the Guam Supreme Court, we have the same separation of powers issues as the federal
But
government.
jurisdictions have the same separation of powers issues, yeah.
Their
Does
constitutions
not apply
are
to them
different.
and apply to us. Because you're saying the Organic Act, but they have their own statutes that are similar.
They have their own
Constitution.
constitutions, which have been
Yeah.
interpreted by their Supreme Courts in their own way. Our Supreme Court and the Ninth Circuit has said our separation of powers is interpreted strictly as in line with the federal government. We don't have non-governmental entities that are independent of any of the branches. All of the autonomous agencies in Title 12, like the airport, the port, all of those are in the executive branch.
No, in the federal government too, like what about the Federal Reserve and that kind of stuff?
That's an answer that is still an executive branch function, and the executive appoints all of the people. The issue with the Federal Reserve is, can the president fire them or not fire them? Like, that's an issue. But they are an executive branch because the president controls the appointment of those people. There are no totally independent, not under a branch entities within the federal government. The Congress has set up some of them where it limits the power of the president to remove the people, but they're still within the executive branch.
Public defender, the federal public defenders is not under the executive branch, it's under the judicial branch.
That is by specific legislative determination.
I just,
Yeah.
I
Yeah,
just
go ahead,
I just
Ricky.
have a question, because I guess just reading some of the pre-briefing documents, I understand the argument about being in a branch, but I guess what had changed, kind of the overarching things that made it change between this PDSC, the current one, is that we included private attorney panel, which was only under the judiciary control. So I guess Sixth Amendment Center wanted to say, hey, we got to make that kind of less dependent on actions of the Supreme Court. That was pulled into PDSC. And then the Chief Justice and the presiding judge on the prior board, that has an appearance of dependence. So they pulled that out. But then everything else, I mean, maybe just generally would remain the same, right? So is there a way, so my question is there a way that we're still under the judiciary because the Sixth Amendment requires it to be a judicial function? Is there still a way to be under judiciary from that standpoint? But the Sixth Amendment Center obviously was recommending to pull those two parts out of the judiciary because they have direct influence on that. They even spend money on that because the judiciary has its own accounting, its own procurement. Public defender has its own accounting, its own procurement. So administratively, we are not under the judiciary, but we are still can we still be under the judiciary, not administrative?
Yeah, and that's, and
I
that's
think that's
what I mean by saying you fall under the umbrella of the judiciary, so we're an entity within the judicial
But the
branch.
specific question, can you be under the judiciary but not administratively?
Oh,
under
yeah,
the judiciary?
definitely. I think
That-
so.
yeah,
That's how
we were-
we've been
we were
operating
before.
since, for the last 50 years. We've been operating under a board that was not directly under the control of the judiciary.
But does that fulfill the question of what branch we would fall under?
Yeah,
Can we fall under a branch for the purpose of Sixth Amendment? That's our whole goal, is to provide.
Yeah, that's-
defense,
that's-
And then administratively, we are separate.
yeah, exactly. That's what I think Public Law 3848 makes clear. So when Public Defender Service Corporation was first created in 75, right? That question was unresolved. Then in that PDSC versus Bordalio, there's a court ruling that took that statute and said it can't be an executive branch agency. It falls within the judiciary.
So if
And so
if
there's
that,
a court ruling that already controls my behavior. I have to follow that law because that is what defines our corporation.
so, I mean, if that answer is,
Until that case is reversed or something.
so I guess my question is, because we're on bylaws, right? Some
Yeah.
can't bylaws, and it says, there's some sections here that refers to 4105, which is the creation of rules, which every agency creates their rules for their purposes.
Yes.
It says 6303, Title 4, which is choose judicial, legislative, or executive branch policies or rules, which is 6303, which is referenced in the bylaws. And 6302, it says this allows the Board of Trustees to establish policies. So those are very specific. So 4105 is just, I just read it, it just identifies agencies that can create their own personal policies, which includes Board of Trustees. 6303, which says creation of positions in the judiciary or the legislature, or the creation of positions in the executive, so we choose which branch we would choose, and 6303 says, it just says creation of positions for the judiciary specifically. And then it says 6302C is allows the Board of Trustees to establish policies depending on which branch we select. I'm just looking at these three because it's referenced in the, and then it references 23109, which is travel rules, which PDSC follows judicial, I guess. Travel.
Yeah, well, we follow the rules that our board will pass.
I'm just wondering, because these are the administrative.
Yeah, they
These
are.
are the administrative things
That are
under,
referenced.
that are identified in the bylaws.
Yeah.
So I guess the question of administratively, if we're under the judiciary for Sixth Amendment, right? And that's how we carry out what we're doing, but administratively in our bylaws, we're referencing the adoption of policy and rules. And it references 6302C, 603, 6415, Title 4, and then 23109. These are like, seem to be very specific to judicial or PDSC Board of Trustee kind of powers. But is that, I don't know, does that take us out? I mean, is there anything in there that ties us to the executive? Like, how do you do your personnel?
No,
don't
like,
have
if I
anything
can, if
that-
I can offer a little bit to that, so like when I was at the OA, the personnel rules for public defender weren't ever a consideration for people. Right, we didn't administer them because it was always privy to the board's discretion on whether to approve. So that wasn't required to come through us for review and approval. Right, just to shed light on it, because it's not a consideration because it was considered under the judiciary. Now, under 3848, it maintained those same laws, right, that kind of gave it to the board today. So that's why I'm adamant about the fact that it stays with the board, because even 4105 brings it right back here, even though it's an executive type statute. But it also includes all those other boards and commissions with the same authority, but acknowledges that this board approves all personnel for here.
And that's what makes Shane's job so difficult, is he's like a DOA for our entire agency. We handle our own procurement. We have procurement rules we follow that were passed by our board. We handle our own personnel. We pass using rules that were passed by this board, and we don't go to the Civil Service Commission. We never have. This board acts as a Civil Service Commission for employee grievances. And also, yeah, personnel rules also are handled completely in-house, and as well as procurement. So everything, we operate under rules and regulations that are passed by the board.
Right, and to my knowledge, the intent for 3848 wasn't to unwind all that, because absent what we do here on the executive side, there's a whole bigger mess to unwind in statutes as far as personnel, procurement, and anything else that's really.
Yeah, because if that was the intent of Public 3048, it would have stripped out all those references and it would have had a simple line saying you fall under the executive branch. So why would they give board the authority to create rules and regulations if we're just gonna, we have to follow?
And the fact that, the bill repealed and reenacted those statutes, it would have repealed those relative statutes, right? Or had a clause in it to repeal anything else that would have made us purely executive. So 4105 wouldn't have affected the Board of Trustees if the intent was to be executive. So that's my understanding. Go ahead.
I do have a question. I'm not too sure the speed at which we're trying to move in approving this. I see Jeff's point, I see the board's point. Is it possible to either one or two things, get clarification from the legislature on its intent? Is that something the board can do? Or number two is we push to get the definition of agency under the AAA to include the PDSC.
Well, so the AAA used to apply under the old statute when it was passed 3048. They specifically eliminated the requirement of AAA to our bond laws. That's why it's so when the legislature takes away a formal requirement, it doesn't. It would contradict the legislative intent to follow this part. But we could definitely table this and address it. Because really the bylaws, the proposed changes are just to make it consistent with Public Law 38. So there isn't anything in the bylaws that need to be changed today. So if you want to.
And just to add back there, because, we went through the exercise of trying to see what happens if you convert PD to an executive branch agency, right? Comply with all of those. Back to John's point about conducting judiciary business, right? Basically, once cases get handed down to us, we act in the processes and procedures that are given, and we move on the court case and whatnot, right? Trying to do that in a different manner. It'd be a huge undertaking that I think would require more legislation to weed out, because we're going to hit these crossroads everywhere we go if we're trying to improve certain things, right? But I don't think the intent of 3848 was to do that. I think it was kind of bringing it forward, put the path forward with PDSC. Notwithstanding what Jeff is saying, like I get his point. It's a perspective, but looking at it through the PDSC lens, right? It's a little more difficult to than just saying that we're taking a branch and going with it, because I think all the supporting statutes, make the same argument that's different branches.
Can you drill down on that a little bit, Shane, as far as what would it be like procuring outside of the judiciary's timeline?
So like, let's say, currently, and let's say if you're to make this a agency under DOA, and those being recorded, I love DOA. But I do know their processes and their challenges, right? So procurement, for instance, right? They do have a pretty robust system, but it does take the time that it does. If we needed to act and get clearance for certain things that are based on court timeframes, there may be a problem. Getting it through GSA quick enough, right? GSA, as far as I remember, is not in the business of giving waivers for anything, or anything. They follow a pretty strict process.
What type of things are you talking about procuring, Shane?
As far as services, right? Like for instance, I think we're looking at, we went down the process of attorneys right now, right? Our procurement regs consistent with the judiciary.
Attorney procurement is done by the agency, not because it's professional services. It's done by the agency under the procurement rules, not DOA.
Correct, but if I can finish, the both procurement regs kind of carve out different processes for attorneys and whatnot, right? So if we become an executive branch agency and we have to file things like contracts, or if certain contracts have to go to the AG, I'm not sure what those may be right now because, currently we don't have to send. It presents those kinds of walls to keeping things operating. So, that's just surface level, right? Without actually executing a process to see what would happen. So, it's things like that operationally, outside of the discussion of the debate on the Organic Act, operationally, where does that leave us with providing the service of our?
Yeah, and it could affect things like HR, right? If we had to use DOA's HR, really, representing indigent defendants. And that's the reason it can't be in a political branch, because it's not a very popular thing. And we're gonna be prioritized after the hiring of police officers, firefighters, teachers, nurses, and probably even after, what other agencies we be prioritized below. But, we have the beauty of being able to implement per rules and, our HR rules, under the guidance of the board. It's something that was never, envisioned that we would fall within the executive branch. In fact, I couldn't find anything in the legislative history where that even came up, because had, this issue been raised at any of the public hearings or any of the forums that we had to discuss the bill, we would have made it, we thought it was abundantly clear that
Well-
we've been the last 50 years under the judicial branch, and that while we're still staying within there, but we're not having our board, chair and vice chair be sitting judges and justices. So it was to get some independence from the judiciary, but it wasn't to create us, a fourth branch or to be within the executive branch, right?
The legislative history was clear that they were removing the Public Defender Service Corporation from the control of the judicial branch.
Well, I guess by removing the chair and vice chair, that's the extent. And also I'll give this board the authority to promulgate rules regarding, appointment of counsel and.
The discussion was to make it independent of the judicial branch.
Well, any other branch,
Yeah,
but
Well,
point is taken.
Specifically, it was a discussion of independent from the judicial branch. So if that was the intent, to remove us from the judicial branch, then
well,
I mean, no, you go ahead.
I just want to make one other point, Jeff, to that is independence from the judiciary, in the sense that we were asked to do things where, as managing attorneys and public defenders, provide things to judges who we had to appear in front of. So it was more of that type of independence that, we're asking for money, yet why are you doing this in my court? I mean, that's the type of independence we needed. And I mean, you used to be at APB, you understood that type of thing.
right. And if we're still in the judicial branch, we still have to answer to them in that way. Because ultimately,
But
We
they're
would-
not overseeing our finances. Because that we would have. to
yeah,
ask
or
them.
HR. So, if we look at, so you won't even get to legislative intent, because I think it's unambiguous from the statute itself, right? That we fall within the authority of the Supreme Court, right? And we're a judicial entity.
no, it says we're under, the statute itself says we're subject to the organic act authority of the legislature and
And,
the judiciary.
yeah, exactly.
So it is ambiguous because it puts us equally under that theory, under two branches of government.
Well, it's not really ambiguous if you understand the duties that they have, like the legislature, they really only have the duty to appropriate and also to define, certain responsibilities of an employee. And so everything else obviously is under the judicial branch, like handling the appointment of counsel and anything related to the providing the right to counsel, right, for those constitutionally entitled to one. And so, I think it's clearly the legislature's involvement is really their, their ability to appropriate funds, right? And then the judicial would supervise the actual
It's not what it says.
counsel. Well, yeah, not in those direct
That's,
terms.
well, you're saying it's not ambiguous. Because of the way that it was drafted, it's ambiguous. So, that's why there's an issue.
Well,
It keeps saying it's
other
independent.
theory is that it doesn't fall within the executive branch, because nowhere in that statute does it say the executive branch And nowhere does it say that the board doesn't, we wouldn't even need a board if we were under the executive branch.
Sure,
Under your-
sure we would. We could have a
Because that-
board under the executive branch. All the autonomous agencies have boards.
All right, well, and then the other thing is, so if you do look at legislative history or legislative intent, if you look at the committee report itself mentions that it clarifies, let's see, it preserves judicial authority and clarifies oversight boundaries. And so I could share this, let me share this.
Right. So what we're saying is we are a judicial branch entity. That's all I want to clarify, because at the last meeting, your position, Steve, was we weren't under any branch.
Well, no, at the last meeting, I said we're under the authority of the Supreme Court and the legislative's inherent and organic act authority, right? But anyways, this is from the committee report issued after the public hearing. And they did say that the intent was to reaffirm the Supreme Court of Guam and the legislature's constitutional and statutory authority under the Organic Act. And clarify that PDSC is not a separate branch of government and remains subject to government oversight, including judicial and legislative authority.
Yeah.
So, I mean.
Okay, that says,
If someone were to actually try to litigate PDSC versus Bordalio, the Supreme Court would analyze it this way, right? The separation of powers issue. The first question they'll ask is PDSC performing an executive branch function? That's question that was answered in PDSC versus Bordalio.
so we're saying we are a judicial branch entity. That's the only question I've been asking all the time, is what branch of government controls? And you've been giving me a runaround about legislature, not executive, judicial. That's all I've been asking, is identify the branch under which we operate.
I apologize if I didn't make it
Okay.
clear. I thought we're under the umbrella of the judiciary, but
Umbrella of the judiciary.
Okay, so then all of our processes need to be consistent with the regulations of the judiciary.
Well, I think they need to be consistent with what the statute says. I mean, so if the board has authority to do certain things, the board should exercise the authority to do those things.
Right, but the exercise of authority that is delegated by the legislature cannot be open-ended. The legislature has to give us parameters of what our rules and regulations have to comply with. So if we're part of the judiciary, then we need to comply with the broad requirements of the judiciary. That's all I'm asking. Because, the United States Supreme Court has said that a legislature cannot give an agency carte blanche to create its own regulations without guidelines. That's abandonment of their legislative regulation. So we are now part of the judicial branch.
All right, it doesn't appear we're gonna get anywhere with this particular motion table right now. We do have this pending question as to what branch we fall under.
I thought he just said we're all judicial.
Yeah, I'm fine. If we're part of the judiciary, that's fine.
Everybody else agrees. Do we have a motion or something as to the interpretation of the statute?
I'll make a motion that pursuant to the discussion that we, as the Board of Trustees and the Public Defender Corporation of Guam, are part of the judicial branch.
There's a second.
Citizens of the judiciary, but they don't oversee this board.
Is that a?
Can you
It
say an
doesn't need to
umbrella?
be a
People
motion.
under the
Well, first of all,
umbrella?
is there a second to that
Wait,
motion?
wait a minute, but we don't, are we starting to change the intent of what the legislature wanted to do with this? They wanted to make us separate from judiciary as far as this function is concerned, but not under.
Wait,
the
point of order. Before we get into discussing about this particular motion, is there a second to it?
I'll second it.
Okay, And
for the
then,
sake of second.
now you have the floor to.
So, first of all, I don't think we want to change the intention or the intent of what the legislature wanted to do for us. And I think we said it in the beginning, they just wanted to make sure the legislature, that the courts, the justices weren't on this board panel. Am I correct? Is that what they wanted to do? Yes, they
So
wanted
that's
to
a-
remove them to oversee us.
Right,
Is that a
right,
correct
yes.
statement? Everybody, John, that's a correct statement.
Independence was the,
Private attorney.
And the
Yeah.
private
goal.
town, but we all agree to that. Is that correct? Is that a correct statement? Yes, right? Otherwise, why do we need to vote on it or say anything? I don't think it's why are we trying to change what the legislature gave us the authority to do? Right? They did what they did. They appointed who we did. I think what's more important here is we got bylaws that we gotta get through, and we've been talking about this subject for almost an hour now. We've been belaboring this issue when we have other issues that we should talk about. And I'm not saying it's not important, but we've been operating like this, and it's why do we need to fix what is not broken? They clarified something for us, two issues they clarified for us. We still are operating as we did 30 years ago. Am I correct, Steve?
Oh, no, absolutely.
And, am I correct? So now, there is a more pressing issue at hand. We need to start talking about like the bylaws,
okay,
and we need to vote on it. But I didn't have a suggestion. I was hoping they could take this suggestion. But whether we're tabling or not, I don't think it's an issue that we need. If we all understand what I just said in this room, why are we voting on it? We don't need to vote on it. Is my.
Well, we do have to vote on it because we're not an independent entity within the government of Guam.
The judicial, John, we are with under the judicial in the sense that. Help me out here.
But we're performing a function that the judiciary is constitutionally required to provide and protect. And it's not an executive branch function. So that's why, if someone ever challenges the case, that's the first question the Supreme Court's gonna ask.
But it is an executive branch function in many states.
Well, but we're providing a constitutionally protected right, and the judiciary on Guam, at least according to that, they would have to reverse that PDSC versus.
Understand.
Opinion. And so that's the existing law of the land, and that's what I.
So the existing law of the land is we are part of the judicial branch. That's what PDSC versus Bordalio says. We are part of the judicial branch.
And we followed that guideline until like last month. So it doesn't change anything for us to say that we're technically under the judiciary, but we have some.
We're not
independence.
technically under the judiciary. We are under the judiciary.
With independence from them set out by statute.
okay, so we have a motion before us about whether we're and as Jeff put it, we're basically, I don't know what the exact words were, I can't remember, but we're under the judiciary. We also have the possibility, is there a motion to amend that to include any of this independence language?
I was gonna go back to it earlier when you were getting to it, as in other jurisdictions, like don't necessarily. A lot of jurisdictions legislatively have them under the executive, but many do have them. And New Mexico is the most recent one, 2012, that established the public defenders as an independent agency that fell under the umbrella of the judiciary. But they had a lot of independence that was built on a commission that similar to what we have right now. So although they have independence, they fall under because they perform solely a judicial function, which is indigent representation.
So I keep hearing all the same argument. Is there a separate motion other than Jeff's motion to include language?
Maybe to amend his
that says
motion.
exactly what you're saying. We're under the judiciary
Why
with
are we
a,
trying to change it? Say, are we in the position? Do we have that position to do that?
I don't know.
Just because he brought it up, I understand why or what he's trying to say, but I think we're trying to do, is it the intent of the law that we're trying to do? Or are we trying to do it to the letter of it, or whatever?
Well, I think, we're free to interpret what this law is as the agency who's tasked to do this. And it's a kind of central question to anything moving forward. What branch do we fall under and how do we fall under that branch? So,
Yeah, Mr. Chair, I just had a question, just because, so the motion is to, I guess, make a statement that we are under the judicial branch. That's the motion.
the current motion before
So
that,
I'm just kind of procedurally, because the agenda does not actually include this discussion. We're discussing it under the item 6A Board of Trustees bylaws. And so, not to say that I don't want to dispose of the motion, but my question is, can we adjust the motion? Because if we are determining, and if we all agree that that is, we're under the judicial branch, for the purposes of this bylaws, does that then kind of address this issue of not getting bylaws?
Mr. Chairman, I'd like to make an
Yeah.
amendment to my motion.
yes,
We recognize, we acknowledge that we are under the judicial branch and that the construction of our bylaws as we enact them must be consistent with the requirements of the judicial branch.
anybody second? The amendment? Second. Okay. Do we need any further discussion on that amendment? No? Okay, then I'll put it to vote. All those in favor of Jeff's motion to recognize us as under the judicial branch, subject to I don't know the exact words. Anyway, all those in favor, can somebody give me the exact
Jeff,
words
can you
again?
Can you repeat?
Right. The amendment was that we're under the judicial branch for purposes of our bylaws for determining the construction and of those bylaws. So they have to be consistent with the requirements that would be applicable to the judiciary.
All those in favor of that interpretation?
Aye.
Aye. Anybody else? Is anyone please? Okay, then that interpretation. No, that interpretation passes.
Okay.
Okay, and on, we can move on. Well, still before us is the bylaws now, because we've gotten past this question that was plaguing us, so. Under that interpretation. yes,
Sorry, sure. Just to clarify, because it's the bylaws. For the affirmative action, was it a vote, Steve, you remember, was a vote of 3 or 4 to pass something?
Yeah.
Okay, and so on the 2 ayes was,
Me,
moves
Jeff.
and
Ricky and.
With Christiana.
Someone.
Yeah.
sorry,
Oh,
this,
Yeah,
Christiana.
Christina.
you're a,
Aye.
just
Yes.
for record. Okay, thank you.
Yes.
Made it for record.
That's cool.
Yeah.
Yeah.
Oh, yeah,
That was motion. That was
Yeah,
the,
on the amended.
on his.
that was the amended motion that we voted on.
Which you seconded, Ricky seconded.
Yeah,
Okay, sorry, just needed that for record.
okay, no,
This-
please, let me know when we're caught up in all this discussion. So now that we've passed this interpretation, can we now move to the bylaws?
Mr. Chair, I'd like to move to remove the rules from the table and subject to discussion.
Move the rules from the table?
They were tabled at last.
Oh, okay. Oh, okay. Do I have a second to that?
You want to get the bylaw back on?
Move it out of,
Yeah.
it was
Oh.
tabled in the last, move it out of the.
Yeah.
Put it on the board.
Yeah,
Second,
okay, I have a second. Any discussion? To the proposed rules?
we're in discussion, right?
Yeah.
Oh, just moving back in, okay,
And-
just moving it back in.
Okay, okay, okay. All in favor?
Aye.
Seems like that's it. We're good with quorum. Okay, okay, so bringing it back off the table.
I'd like to make a motion to approve the bylaws.
Any second? Second. Okay, any discussion related to the bylaws?
Did we want to go page by page on the approval, or did we just want to just approve it now?
Well,
Because
if
not
there's-
everybody here was here when this is actually put together, there was two of us.
I think that would.
That's-
I don't know for sake of time or whatever, I just wanted to make sure it was brought to your attention and not everybody was here when this came up, so.
I've read them. I don't know if everybody else has read them, but if there's call for discussion, I'm certainly happy to entertain that. From anybody that wants to know any specifics. What we're trying to enact here. Yes.
Chair, if I can, I mean, if there is a call for discussion, I know in our previous board packet, there was a breakdown. Comparison
Yes.
between the previous, we can recirculate that, just that, not the rest of the 200 pages. We'll just get that portion now, I mean, but.
I agree. That would be.
Okay.
He-
And kind of give the reason why the changes were made, so. that was for consideration.
Mr. Chair.
Yes.
Having reviewed the bylaws, and now that we are clear that we are interpreting them as if we are a judicial branch entity, I believe that the bylaws, by my reading, are consistent with the statute and are consistent with the requirements as laid out in the statute. And because we do not belong to any other branch, are consistent with what we're able to do under the judicial branch. And that I don't see any real problems with them.
Is there anybody else that would like to go?
Yeah, just, in my review of the bylaws, I was looking at section 1.02 regarding regular meetings. And, the language, requires, of course, monthly meetings, but it also is very restrictive on it being required to be on the fourth Tuesday of the month, and other boards pretty flexible with the members, with the trustees, availability. And I wanted to see if we could make that a little less restrictive to the fourth Tuesday of the month, and just make it maybe the fourth week of the month, or something like that, just because it says shall be held monthly on the fourth Tuesday of the month. So I don't know if there is flexibility within that language that maybe the attorneys can mention, but I just wanted to be less restrictive.
It might be the chair.
Yeah, the exception is emergency, and I don't know if that's determined.
Yeah, with determined emergency.
I mean, we really don't like the 14th day of the month because of, you should give us a couple of days to get our budget out. So then we'll just move our budget presentation a month earlier. It's usually at the first of the July, right?
Usually May, I think May
May
1st, they were
1st,
starting
May
with
1st,
the-
and our last Tuesday of the month sometimes is.
It creeps up for like 2 days before that.
Yeah.
And the.
So I'm just wondering if we could just keep it at monthly and then subject to the availability of trustees.
So we vote on, not vote, but just decide on the
Yeah.
next date. after.
Yeah, I mean, we could like, like other boards that I've seen that they've just decided internally. Without having it to be, bylaws, that we just say, let's say we'll just target this Tuesday of the month. But like
Make
we
it
have the
general.
meeting, just have to work out all. I just was wondering, because this is very specific on the thing.
Yeah, so. I mean, so we submitted these proposed bylaws at the last board meeting, and maybe we don't know that, so. One of the requirements is that an amendment be submitted, and then it can't get voted on until the next board meeting. So-
Well, then I wanted to, because there's some stuff I want to go through.
Yeah, so we could go through the bylaws and have written amendments submitted, and then it'll. Come in at one board meeting and then can't vote on it until the next board meeting. But these
So should
were,
we tell you now what you want, you have a question on?
oh, sure, and we could try to include that as.
Well, he was at the one first, so let's address it.
Yeah, so we could look at other boards.
Are you saying that we should adopt this today and then we'll make amendments?
Oh, yeah, if you adopt this today, then it's already been submitted to the board previously, but new amendments, we would have to.
It will come up with the agenda.
No, I'm asking you, are you suggesting we should probably approve this? And then
Yeah, so
make
that's what I would
amendments
recommend, because just because these are the statutory changes,
Yeah.
they,
Okay.
to be considered the statutory change, and then these ones like the date and time
later?
and
We can make changes.
even, we could draft the
That's fine.
proposed amendments. 'Cause it has to be
Okay.
submitted and written.
So since he brought that up, like, I just want to ask to make it clear, like on quorum, it says no less than 4 members of the PDSC board shall be, I understand. But virtually, the word virtually is not there, does that matter? For purposes of by no action shall be taken without these 4 affirmative votes, but could they make quorum virtually because it's not stated in. And I just know this because I had asked the question like on the GIA board, they have to be. Even if they're not in the conference room, they can participate, but they cannot vote and it does not constitute quorum. And it's been brought up in our other boards. So because, since COVID, things have changed, I'm wondering if there's 2 things I want to ask the question on. And one of them is that, can us being like today, Mr. Moots and Dr. Chrissy, they're not in the boardroom. We accept them as quorum, but should it say here virtually? That was one of my questions.
Yeah.
I think
So-
it's in 1.07.
Yeah.
Method of voting.
No, yeah, I know, but,
For quorum.
but I'm talking about quorum, and because they separated here.
Yeah.
One's quorum and one's method of voting.
So there's a general, so like our public law 3040, it does specify that board meetings can be conducted virtually. And then there's a board and commission chapter. Top of my head, but there's a provision that allows testimony meetings to happen virtually, and then participation virtually does not affect the quorum requirement. So I think we're on board legally, thankfully, because I think the last 5 years we've been doing a lot.
But that was just because the
Yeah.
emergency and then, but I'm just asking you, it has to be stated. That's what I'm asking.
Yeah.
And I think 101 though, place the meeting, if we're gonna be specific on the place the meeting,
Yeah,
if you wanna
because
put it
there,
virtual, then.
thank you.
the meeting will be done through the
Yes.
also.
Yeah.
So at this point, are we comfortable? Is everybody done with this discussion that we can vote on these particular bylaws? Subject to the idea that there's been discussion about amendments in the future.
I guess, are we comfortable as, at least for the virtual part, to move forward and then amend it, or make a change before we vote on the bylaw?
But he says if we make the change, period. I mean, it can't be until it's.
Yeah, it would have to be submitted in writing.
But will we be allowed to move?
But then we're subject to this language.
That
until
next
meeting, yeah.
Can we just direct them to send, to draft out the thing? And then we just delegate that to them?
But you still have to,
We could prepare the changes for you guys and submit it to the party next
Approve
week.
this subject to, and delegate you the authority to make the change to allow for virtual. And
So that particular amendment would need to be submitted in writing with that. But the law already authorizes us to do it, so, the law trumps the
But
bylaw.
this hasn't been adopted yet. right?
Yeah,
yeah,
yeah.
we have to adopt it.
We can make amendments and
Then
then.
if
and
we
then vote on
adopt
it
it,
later,
but
yeah.
if we're gonna adopt it now. I guess the question is,
Yeah.
Are we not?
You could adopt what we have now, and then we could submit the written amendment.
And then
The next one.
approve it to next meeting.
Yeah, we really have 2 choices. We can move forward with this one right now, or we can move to amend what's presented right now, what we presented at the next meeting, and we don't.
I mean, is there a huge rush? Is it gonna hurt the?
For us to move this to the next meeting.
Oh, no, because it's just consistent with the statute. So the other changes everyone's suggested might, like date of the meeting, that's preference. with the board, so we could,
So,
And if I may, I think I would like to see also the changes in the chain, proposed.
Yeah, the comparison.
So maybe if we're still gonna move it to next meeting, maybe without adopting it, we could still add more,
Yes,
as
as we look at it.
Yeah.
I was hoping to go, page by page on
Yeah.
it, so that we are all on the same page, but if you don't.
May I make a suggestion then that we vote down my motion?
I was just gonna say that.
Yeah.
Procedurally, let's have Jeff's
Okay.
motion to adopt it as is, and then
okay,
there's another motion.
And
All
yeah, then
So
further on,
let's-
we can do another motion to next meeting, go through them page by
let's
page.
take a time, let's take a vote on this.
So he made the motion, I think. we'll just need
Is
to
there
second.
a second? I lost track.
There was no.
There was
second.
a second, Shane.
Oh, there was, okay, sorry.
Oh, Ricky.
Ricky, okay,
Yeah.
seconded, so. just-
Okay, so I'll put that to vote. All in favor? All opposed?
Aye.
Aye. Okay.
Can I make another motion then?
Now the next motion.
Can I make another motion then that we?
Is there
put-
another motion
There's a
now?
motion.
Okay, that we put on the agenda for next session to review
Yes.
the bylaws, section by section and make necessary amendments.
Is there a second to that?
Second to that, thanks, Jeff.
Okay, go ahead.
discussion, and then can we also circulate the
Yes.
the changes
The
for the
analysis.
next, yeah, the announcement.
Yes.
Okay, there's-
So it's your measure. And whoever else.
So, well, do we submit that to Shane or Shane?
Submit it to the Shanes.
To the- Another
All
machine.
Shanes. Yeah. Two Shanes are better than one.
And that's a written, right?
Correct, so that the language is, it's clear for the.
And it'll be incorporated in.
yeah, we can draft.
Provided for the next meeting.
Correct.
And I'm sorry, then you would produce it to the rest of the board before?
Before the next
Correct.
meeting.
And the amended version. Can show the change.
Okay,
I mean, we're lucky to have a good work.
okay, so we can,
So there was a second,
there was a second, we voted.
The
Yeah, so Jeff's motion didn't pass.
first motion didn't pass, but the second motion.
That's right, the second motion,
passed.
yeah.
Add it to the next.
Right, added- yeah.
Do we all agree? Yes.
Did we? Oh, we did.
Oh, we did, yeah.
Yeah.
So
No,
I
okay, we didn't do that. Okay, sorry, I'm losing track here.
Yeah.
All right, we all agree.
Yes.
Aye.
Aye.
Okay,
Is there a deadline people should be aware of for the submission of any requested amendments?
yes, so generally we try to send the board packet out, at least in this case, the Friday before the Tuesday. So, once the date's established for the next meeting, I can actually email out, when, we can receive things to make those changes.
Okay, thank you, Shane.
okay.
Are we
So
deciding on the next meeting?
It's on the Tuesday. before-
the 14th, right, it's on the 14th right now. Okay, are we done with old business? Did we have anything else to?
Mr. Chair, I don't want to be rude and just jump up, but I need to go cover court, so
Okay.
thanks for the productive conversation.
Thanks, John.
Thank you, John.
Thank you.
Did we have we had something about the EMP panel.
Well, so we were gonna do division operational updates, but we could probably.
Table it.
You
Table
can-
that.
Keep that table, the EMP stuff.
Yeah,
Yeah.
the main thing was the investigator rates, if you want them on the website.
Okay, so we can move on to new business. Then,
Oh, yeah.
No, it's not on the,
It's-
yeah, it was only the bylaws.
the bylaw, old business rule, and then the new division operation updates for these stats. Okay.
And then the investigator rates.
Oh, yeah, investigator rates is too,
Yeah,
but
so if we're ready to move on to the business, we'll go ahead and do that, so. You guys have some presentation as to the stats. but-
You want us to table that or?
We'll get table that we're compiling our annual.
So I mean, just in general for the updates, we were looking at quarterly updates, right? We are trying to put together a year-end update for FY25. But quarterly updates, unless the board wants to see anything more frequent, right, with our stats. We want to just produce what we're mandated to do and we can go from there. But as far as year-end stats, we'll put it together for the November meeting, and then we kind of build it from there.
public health authorities.
I mean, like number of cases.
Oh,
yeah.
How many would you
Do
do?
I have a motion that to table the?
Motion to table
Statistics,
the statistics and the.
second?
I
Any
second.
discussion? Okay. Any discussion following that? Okay, all in favor?
Aye.
Aye. Okay.
Aye.
Okay. And then we're going on to the standard operating procedure for investigator rates.
Yeah, I'll address that.
Yeah, if you can address it quickly.
Oh, yes.
So, currently we have an investigator cap of $2,000, but there was no hourly rate set. We looked at several jurisdictions, $75 an hour in Michigan, and parts of California as well. And, other places $50. So somewhere between that range. The investigators I've talked to involved had previously, some were charging like $100. We believe that, $75 an hour would be a fair rate, given the $2,000 cap. And, the right to an investigator is, it's very important to be an effective attorney. Can't really do a trial without an investigator helping you interview witnesses and, give up leads. And so, we're hoping to establish a panel of anywhere between 4 to 8 investigators who are willing to take on these cases.
And then just for clarification, it's for the private attorney now.
Yeah.
Right.
Yeah, it's kind of unfair, like our clients at PDSC and APD, because they have access to investigators, the representation, obviously. I think it's a lot better, and so we want to make the representation, give the private attorney panels the same kind of resources that PDSC and APD attorneys have.
I imagine, my one concern, although I agree with everything says, is we don't have bylaws approved yet. I think is it appropriate to move forward with this?
Well, it would just be amended to the existing SOP,
Just a SOP.
just that it be a rate of, because they already set rates for attorneys in the SOP as well as the paralegals, but it did for some, I'm not sure why it's been set on for investigators.
What is the current, or what is the judicial, path on the judiciary? Set it at?
There's no rate.
Have a rate, so.
It's
Just a maximum amount.
They didn't have any
Just
investment.
not to exceed 2,000
Yeah.
and not to exceed 5.
So if your investigator was $500 an hour, you didn't get.
Get 4 hours.
Yeah.
Yeah, it was just a 2,000 max.
So, we're gonna develop an investigator panel that, retired GPD or retired EG investigators, and they're they're willing to work at 75 an hour. Because they're starting it's like a retired career, so.
That's a dumb question. The investigators that you guys currently have under who will they be investigators for?
Yeah,
So do they have the same ethical standard as an attorney or paralegal?
That's
there's-
not a dumb question.
No, yeah, it's a really good question, but there are certain conflict issues that still arise, but I know we could find a workaround, that would be great, because we have really great investigators. But we will be trying to get them to train, new investigators, so there'll be a resource, but they just can't share information because it involves the same proactive. And it's come up pretty recently, actually.
Because there's like standards for being an attorney, maybe paralegal, they're like, was an investigator like a profession that you
Yeah,
can,
see,
you have to procure it?
Guam doesn't have a licensing requirement other than a business license, so I had to get a list of investigators from Revenue Tax, so they give me a list of like every sole proprietorship business service provider. I guess there's a listing for just service providers, and there were only like 8 investigators, and half of them either are retired now or are only doing things for they went back to work at GP. So we only got like 3 or 4 for now.
Noreen, to answer your question, it does create an ethics issue. Because if they're co-defendants and one pleads and the other one's going to trial, you don't use the same investigator.
But there are jurisdictions where they have like in San Mateo County, they have a managed assigned counsel, so they don't have a PDSC or EPD. All the indigent defense works done by private counsel, and they have a private council investigator panel. So but the investigators, they're maintaining conflict walls, with other investigators. So, yeah, I mean, it would be great, because we have really good investigators.
Yeah, estimated funding.
Oh, no, it's kind of, last year they spent like 27,000. But,
In total,
yeah,
year?
for investigators, but I don't. I'm
But
not sure.
you're not asking at this point to change a maximum or set a maximum.
Oh,
It's
yeah,
just the
we're not
hourly
asking,
rate.
yeah, just the hourly. rate.
Yeah.
And that's,
Right.
I guess that's my question is, we're limiting then the investigators' time, they'll reach the cap at a lot lesser time period, right, like 26 hours versus 40. But is that impacting, I guess, I mean, is the push to give them, I guess I'm trying to balance the time of the investigator's needs versus the hourly rate for the investigator. Because it does limit the investigator's hours per case, but I don't know if the push is to balance the current rate of investigators, but that would limit them the amount of hours that they would put in.
Yeah, that's correct. I mean, they'll work. I mean, some that bill $200 an hour, they probably won't wanna, but we have enough investigators that will accept it as 75.
at 75, it's a
Yeah.
good rate.
And really, with 26 hours, it doesn't seem like a lot, but attorneys know early on if it's gonna go to trial. If it goes to trial, it might exceed the cap, but if it's not going to trial, then you probably will be able to do it within 26 hours, you know?
As long as it doesn't impact the current work of the investigators to prepare for
Yeah,
the case.
and it'll, so right now, the lawyers are doing the work with the investigators, so it's gonna bring down cap costs, I think, at the other side. So like the attorneys are doing all the bail motion work, they're doing TPCs and presumably preparing the documents for it. So if an investigator is working on that, it's still be billing like half the rate. So,
Your proposal is to add investigators in addition to attorneys and paralegals to the policies.
SOP?
yeah, the SOP already exists
Just
for
the hourly.
investigators, it's
Just
just
the
to add an hourly.
It's already there.
It's already capped at 2, but they want to add this $75.
Yeah,
But you're not gonna put at $75 an hour, capped at 2,000?
Yeah.
That's what you're gonna.
So
that's
The
what
cap
it's
is staying. It's
Yes.
just-
The cap.
Yeah.
and it's gonna go up to 75, so the most we could pay is 75, so we could find someone willing to take it for 15. Hopefully they're not watching this on. Then, you know, they might be, you know, especially if they're starting off, right, they might be willing to go for 50.
Should this be up to?
Yeah, it's up, it's.
Or
up
not to exceed.
Yeah, not to exceed 75.
Right, but the thing to remember is if it's a really complicated case, they can make a motion to exceed the cap. But
Yeah.
having done a lot of indigent defense as appointed counsel, if you find an investigator, most of them will be more than happy to work at $75 an hour. And they're gonna be able to do most of what you need to do within $2,000.
Do I have a motion?
Motion?
Motion to establish the investigator rate, investigators not to exceed $75.
Not to exceed.
Is there a second to that motion? Second. Okay, second. Any further discussion? Okay, put it to vote. All those in favor?
Aye.
It's like. We've got at least 4 or 5.
1, 2, 3.
I think all 4 of us here, plus Jeff.
And Chris, or
Yeah, Chris.
She's muted though.
Oh, you can see on it?
Did she
Yeah.
vote?
Yeah,
Yeah.
I think she raised her hand. All right,
And we already tabled the quarterly.
Yeah.
right, we
Yeah,
tabled that, so
You
that.
Yeah.
got the investigator.
Yeah, so this will be great because, you know, we picked up about 15 cases for the PAP, and so some of them have been asking for investigators.
Okay.
So this will help get people out of jail faster.
Okay, moving forward. Any public discussion? No?
Motion to adjourn, please.
Second? Second? Yep. All in favor?
Aye.
Aye. All right, we're adjourned.
With the next board meeting, the 25th.
Oh, yeah, the
Oh,
next
the next
board,
one.
yeah, the next board, what is the 25th, November?
25th, yeah.
Thank you, lunch.
Bye, thank you.
Bye. Bye.
Bye, Jen.